Hi, everyone. We're so happy that you could join us today for our Macro Pro and Friends 12 CEUs of Christmas. We're just going to give it another minute or so to give folks the opportunity to log on. Not that we had a little traffic jam, but it looks like there's a few more that are coming in and trickling in. We want everybody to have the opportunity to hear all of the wonderful things that we'll be presenting today. Mandy Farquhar is my co-host today. My name is Wendy Stevens and I'm with Macro Pro. A lot of you I know, some of you I don't. If you have questions, you are welcome to email me at wendy@macropro.com regarding this webinar. Mandy, how are you doing today?
I'm great, Wendy. Nice to see you.
Nice to see you too. You're in sunny Southern California and I'm in foggy Northern California right now. Mandy, are you ready for Christmas?
You know what? I need to get ready this weekend. I got a lot of work ahead of me after 5 o'clock today.
Well, I have a question for you and anybody who's logged in. Are you somebody who wraps gifts or do you put them in bags?
I like to wrap my gifts, and what I do is I wrap my children's gifts with all different wrapping paper. Like each one of them has a different wrap, so then they know which ones are theirs on Christmas.
Oh, I love that. When I was growing up, there's 8 kids in my family. My mother used to wrap the presents and then she would put just the reindeer name. And the funniest part was she would forget which reindeer she would assign to which child. So all of us would have to open a gift. And if it was ours, that was great. If not, we exchanged. And then we found out which reindeer we were. But I love to wrap presents too. Some people are baggers. For everyone who just joined in the question box, let us know. Are you a wrapper or do you bag your gifts or do you have a fun little a holiday tradition that you have? I think that we have quite a few more people that logged in. So we'll go ahead and we'll get started. Today, for this part of our 12 CEUs of Christmas, you will receive 1 California continuing education credit. Your certificate will arrive within 1 hour of the presentation. If you have a problem downloading or if you have a question, please let me know within 30 days. I can help you within those 30 days, but if you ask me in 6 months, we can't help you with that because the system we work within just kind of puts that kibosh on us. I'm not quite sure why, and we don't want the Grinch to steal your Christmas CEUs. So if you have a question for our experts, and the people we have presenting today are an expert in their field, let us know in the question box. We will read the questions at the end of the presentation. I think you're going to really enjoy these folks. They're quite good at what they do. And lastly, we are recording this presentation. So if you would like to see this presentation again, or if you'll have additional questions down the road, you can always watch it on our Macro Pro YouTube channel. So again, if you have any questions, put them in the question box. One other thing, we have a download of this presentation. So if you look in the handout section on the little tower, you can click that and you'll be able to download the presentation. Do that before the presentation is over, because once it's over, you won't have access to that again unless you email me. So without any further conversation, I would like to introduce you today to our speakers. We have Richard Green and we have Rene Casilli, and they are with the law offices of Richard Green. And we are going to just hop right off of here and turn it over to you. So thank you for joining us.
Thanks, Wendy. Happy holidays. Yeah, before we get into it, I just wanted to say a big thank you to Macro Pro. It's a great set of offerings that you do for continuing education, and we're happy to be a part of it. We are huge Macro Pro fans and users of your services, and we've always found that we get good results quick results and full results. So thank you for everything that you do, and we're happy to be a part of this. Good morning, everybody. It's nice to see turnout on a Friday. That's really nice. We're here today, and we're going to talk a little bit about claim denials and what we can do to give you some practical guidance in terms of what things are going to look like at the board level. Before we get into that, I want to do a quick introduction, let you know quickly who we are. Rene Casilli is with me this morning. We are both with the offices of Richard K. Green. Our contact information is on this slide, which you can download as part of the presentation. Rene, I'll start with you. You're a senior associate here at our firm, and you've been with us since the middle of 2019, and we're so happy to have you. You're a certified specialist in workers' comp with the State Bar of California. You have private firm background, right, as a private firm defense attorney in workers' comp?
Yes, and also in-house.
Great, and both of those things give a great perspective, but one of the things I really enjoy about working with you, Rene, is that you also are a former judge from the workers' comp system. You were a judge at the San Francisco branch of the WCAB, and I know I speak not only for myself, but also our other attorneys in the firm and the clients that we have in terms of that being a hugely valuable perspective. Because sometimes, you know, as defense attorneys, we get a little aggressive, and it's very nice for you to add the dose of reality that we need, and for us to be able to test theories in terms of what a judicial reaction might be. So thank you for doing that, and thank you for being part of the firm, and thank you for the most part now for being part of today's presentation. I look forward to speaking with you.
Yeah, I'm happy to be here. Thank you.
Yeah. For myself, I founded the law firm that we're both with back in 2017. We've been growing ever since. We do workers' comp defense. That's all we do, and we do it throughout the Northern California area, including, of course, the San Francisco Bay Area, but anywhere from the Oregon border down to the Central Valley, and including the Central Valley. My background is inclusive also of being a certified specialist with the State Bar of California and workers' comp. I have a background, I'm also fortunate to have been not only with private defense firms in the past, but also as an in-house attorney with a major international insurance company. And I also have experience working for a international hospitality company where I started a regional law office for them, and they're self-insured and self-administered. So that was great experience as well. And I also have a background inclusive of a little bit of HR and business process consulting. I did some work in the past as well as an adjunct professor, mostly on HR topics. And so I apologize in advance to the attendees because I know that not only am I an attorney, but I'm also a former professor, and that means I can be long-winded. So Rene, keep me in check, okay?
You have a lot to say, but it's
never
very helpful.
All right, what we're going to cover today. Basically, what we're looking at is how claims professionals can ensure that they're issuing solid denial letters. And that includes, and this is really the key here, isn't it, Rene, that we want to share not only some guidance in terms of what the law says, what the regs say, what the case law says, but also what we're hearing when we go to the board on these kinds of issues, right?
Yes, and how to be prepared to respond.
Right, exactly. And how to be prepared with good, strong denial if that is the appropriate determination in a claim that you're looking at. And the way that we're going to do this today is very interactive. I'm not going to take the first half. She's not going to take the second half. We're going to kind of ping pong throughout this whole thing because I think it's more dynamic and it's more interactive. And we're going to have a chance to address some questions at the end of this as well. So we're happy to do that. But to break it down into a couple of sections, first one is we're going to talk a little bit about the claim investigation period. And we're going to talk about what it means to make a compensability determination or a decision that makes sense. And then we're going to talk a little bit about practical realities in terms of filing for a hearing on injury AOE COE at the appeals board. We're going to talk about some technical issues, and we're also going to talk about what I term as best practices. So that's basically the format that we're going to be using today. And of course, we'll leave time at the end for some questions as well. We have a good group of people here today, and I'm sure they're going to have some questions. Rene, I know, especially as a former judge, you've got questions to ask. I have always been on the receiving end of pointed questions from workers' comp judges. You're no exception. I think you've got some questions for me, don't you?
So we'll start us off. I think most people in attendance know that the standard period for investigation and making a decision on a claim is 90 days. But if we take a closer look, there have been some recent changes, and there may be, in specific cases, a shorter time frame. Can you talk about that?
Sure, happy to. And as luck would have it, we've got this slide that talks a little bit about it. We're attorneys, so we like to cite labor code sections. Judges always like to see that too. As everybody knows, 5402B1 has to do with denial period. You've got 90 days in which to investigate a claim. It will be presumed compensable if liability isn't rejected within that 90-day claim investigation period once the claim form is filed. So we take the language from the law and we put it right on the screen for you. This presumption is rebuttable only by evidence discovered subsequent to the 90-day period. We're going to talk a little bit more about a few little words in there that are very important as we move ahead. For example, what does it mean that liability is rejected? Does that mean, for example, that we need to send out an actual claim denial letter within 90 days? The answer may surprise some people. But it's also important to remember that, especially with regard to people like firefighters, safety officers, and some others who are covered by legal presumptions of claim compensability, for example, cancer claims, heart issues, and so forth, even the duty belt presumption. The actual claim period for investigation is shortened based on a new revision to the law, and that's now 75 days. So I wanted to put that up on the screen. I'm sure that everybody who is in attendance is looking carefully at this, especially those who do work with public entities and have to deal with presumption cases. But one thing I wanted to emphasize here is that the period is shorter. And Rene, that means, doesn't it, that we need to get moving on investigation as a claims adjuster very quickly, right?
There is a duty to investigate. And I'm sure, as Rich said, we all know that there is a duty to investigate. What is the basis for that duty? What is the law behind it?
Yeah, and I am going to get to that on the next slide. One thing I want to do before we get there, though, I wanted to ask you, you know, these laws, and I'm putting the cursor on that just right now so everybody can see it. It talks about when the claim form is filed. So before we talk about the duty to investigate, what do we do in a non-ideal situation? Let's say we're dealing with an employer who, for whatever reason, didn't show up immediately post-injury with a cell phone in one hand to call 911 and a claim form in the other hand. Reality dictates that not all employers are going to offer a claim form. And so what becomes important, Rene, in your eyes, in terms of claims in which there's no actual claim form submitted by the injured worker?
Date of knowledge of the employer.
Okay. And so that's heavy into factual investigation, right? We need to know more from the employer so that when we go to court, we've got a better idea as to the witness testimony that we might be able to present on that, right?
Correct.
And I always say that it's a good, solid default to rely then on the date of knowledge on the part of the employer. Does that translate, do you think, to the date of knowledge of the carrier as well, or the TPA?
No, and that can create some challenging situations and really shorten the 90-day window.
Okay, yeah, and we'll talk a little bit about, more about that as we move along, but we've all been there when we've had a claim that it was submitted at some point along the way during the 90 days, but maybe closer to the 90-day limit as opposed to at the beginning. That can be a challenge, but there are ways to meet that, and we're going to talk a little bit more about that shortly. So with these in mind, we know we have a 90-day window. In most cases, we've got a 75-day window in some cases. Rene, you asked a really good question. What's the duty to investigate? Where does that come from? This is something I'm hoping everybody who's attending is familiar with, but I wanted to go over it. One of the things that I was asked as a new attorney by a judge back in the olden days when I first started practicing was, have you read the law? So one of the things that I think is a good idea is to read the actual reg. And so that's one of the reasons why we put the reg up on the screen for everybody. It's Title 8, California Code of Regulations 10109. It's a long regulation, I'll say that. It's got more to it than what's on this slide, but I've tried in this particular slide to give the most important aspects of this. And Rene, we're going to go through these one by one. I've highlighted what I think is important. And
Well, I see that you really emphasize the word must.
Yeah, and I'm glad that stood out to you. I'm sure it resonates having some judicial experience in your background. What's the impetus there? What's the importance of that word?
Well, in my mind, must is equivalent to shall. You shall do this, you absolutely have to do it.
Okay, so these are not discretionary things that a claims adjuster or a supervisor or somebody in that office could do or even should do. They're things that have to be done, right?
Yes.
And so shooting ahead later to a hearing at the WCAB on issues concerning the claim investigation, there are questions that are fair game in terms of asking the claims adjuster or administrator, did you do these things, right?
Yes.
And if the answer is, I don't know, or it's not documented in my claims notes, we could run into some challenges as defense attorneys when we try to substantiate that denial, right?
The really important part of that is that the evidence is documented so it can be presented.
Right, and we're going to deal with that. That's one of the bullet points here. Let's start with the commandment, as you very correctly said, that the claims administrator must conduct a reasonable investigation. The real key there for us as attorneys and for the folks that are listening as claims adjusters and professionals is the word reasonable. We may be different people with different ideas of a definition of what reasonable means. And what I'll say here is that you can sort of define reasonable by the rest of the dots or the bullet points on this slide. That, in my view, helps to determine whether you're a defense attorney or a judge, for example, whether the claims professional did a reasonable investigation. First of all, the investigation must attempt to obtain the information needed to determine and timely provide benefits. So if somebody were to contact an employer for an employer level investigation, we were to make a phone call to the employer and we asked some questions, but they really weren't directly on point and weren't designed maybe to elicit the information that's required to make a claims determination, that's not going to do it, right? They need to be relevant questions, right?
Relevant, specific, and directly related to the information needed to make a decision about compensability.
Right. So one of the things that I always recommend is that people do take the time. I know everybody's busy. You guys have a lot of claims that you're handling. We have a lot of cases that we're handling. But take a few minutes as a claims adjuster or supervisor to really think about the questions that you want to ask the employer while you have them on the phone for that few minute period. Because not only do you need to document what they say, but you want to document some things that are really germane or really centrally at issue regarding the claim that you have. And I'll say this too, different claims have different components that need to be investigated. So Rene, I'm sure you'd agree that, this is a situation where it's not going to be a template that'll work for a claims adjuster to ask the same questions in every case, right?
No, and what should you do if you're not getting the information you need over the phone?
Right. There are other things that can be done. We're going to talk about use of investigators to go out and speak with employers and to speak with witnesses. So in terms of not getting answers to questions, there are other sources and other methods, basically. If you're not getting the answers on a telephone call, the next thing to do might be to retain a private investigator to go out and conduct a formal interview of the supervisor, the manager, somebody who may have insight knowledge. Or let's start talking to some witnesses with an investigator as well. It doesn't have to be the employer directly. These can be coworkers, these can be people who may have seen what happened or not. It's also important to document what people are saying they did not see, right? Or did not hear. And
we were talking about a great example the other day of an investigation that resulted in an impossibility of the mechanism of injury as it was reported. Can you talk about that a little bit?
Yeah, I thank you for reminding me about that. This was a case in which we had some information coming in from the injured worker during the initial interview by the claims professional. And the injured worker, the claimant, reported to that person that they fell from a very high height. It was somewhere around 25, 30 feet up, and that they landed on a very hard surface. And, turns out when that same claims professional contacted the employer and did a little bit of digging, they turned around and found out that this person could not have fallen from that height because the roof of the building wasn't even that tall, never mind the height of the ceiling inside where the injured worker was apparently working. So, it can highlight inconsistencies like that when you ask questions. That's really good to remember. I wanted to get a little bit into the fully and fairly gathering of pertinent information. That's also a requirement here. So to me, Rene, and I want to know what you think about this, fully and fairly, we see those words a lot in this context. And to me, that says, should we be talking to both sides?
Both
Isn't that
sides
what a
in
judge
terms
wants
of
to see?
the applicant themselves and the employer? Yes.
Yeah. So as a defense attorney, you're going to want to be able to present, and as a judge, I'm sure you used to want to see evidence that suggests that you spoke not only to the employer, but you also took the time to ask some questions of the injured worker or the claimant, right?
That would be evidence of a reasonable investigation in my assessment.
Okay. And to follow it up, we've got the very important must here, and Rene, you already hit on this, but we'll talk about it a little bit more here. You've got to document the investigatory acts, not only the results. So at the end of the day, if a claims administrator wants to deny a workers' comp claim, they have the right to do that if the evidence points to that. But they've got to document it, and they can send out a claim denial letter, but does that really document the claim investigation? I don't think so. So Rene, where is it that the documentation is set forth? What vehicle should people remember in terms of where to document what they did and why?
So we talked about this offline, and we talked about the use of the claim notes to document conversations, interactions, review of documents, so that there is a written record that's accessible within the claim. And it can also serve as a memory refresh if the claims professional is asked to come to court as a witness.
Yeah, this is great to remind people because, you know, it's fresh in your mind when you're making a claim determination and you're telling your claims assistant, for example, to send out a letter, a claim denial letter. It's all fresh in your mind, or you're discussing it with your supervisor in terms of, do I have the authorization to issue the denial letter? But what we have to remember is, if this denial is contended at some point, and we're at the appeals board, and let's take it a step further, we don't like this, and we'll do all we can to prevent it, but let's say the claims adjuster has to testify at trial as a witness for whatever reason. In that kind of a situation, you're now probably at least 6 months, more like a year down the road from the claim denial, right?
Yes.
At that point, you know, the average person, including myself, is not going to remember the intricacies of the process that they went through to determine that the claim should be denied, and they're not going to maybe remember each exact step they took to investigate the claim. So it's got to be documented. We know that. The claim notes are a good place to put these things. And one thing I want to highlight here, and Rene, chime in as you will. A lot of people just assume that claims notes are legally privileged and can't be released. You've heard that argued at the board, right?
I have. And there can be portions of claim notes that are privileged. For example, attorney-client privilege would cover any communication between claims professional and their representing attorney.
Mm-hmm.
But the bulk of the claims notes are discoverable as part of the file. They're generally not served as routine, but they are discoverable and can be available.
So as a practical matter, when we get a new file from a client, we look through the materials that are offered. Sometimes we get claims notes and sometimes we don't. And if we need to see the claims notes for whatever reason, we request them, and we're usually granted permission to look at them or have them in our file. But the issue of legal privilege is something that we've all dealt with at the board, and typically this comes into play when a savvy claimant's attorney, applicant's attorney sends a subpoena for the claims file, the entire claims file, right? And we respond with, typically the adjuster will send out the communication, the medical file, and other non-privileged portions of the claim file, but they won't maybe all the time send the claims notes. A good applicant's attorney is going to raise that issue if they think that there's something in the claims notes that might dictate that a good faith investigation was not conducted. And it's their right to investigate that via a subpoena. So the end result here, from my experience personally at the boards, both in Northern and Southern California, because I've been in both parts of the state, is that when I'm in front of a judge and I'm arguing about the subpoena and whether or not we need to comply with it, the notion that the entirety of the claims notes are legally privileged is not generally met favorably. And the response from most judges that I've dealt with is, okay, counsel, then you can redact what you believe is privileged and you can tell us why in a privilege log. But the remainder of the claims notes—
sometimes you're asked for a privilege log, which can be onerous.
Right. But that's the way to deal with the issue. And so I guess the takeaway here, Rene, before we move on a little bit, is adjusters should not assume that their claims notes are privileged. So you've got to write them with a goal of documentation, but maybe without anything beyond that. Leave opinions out of it. We'll talk about opinions and conjecture a little bit more as we move along. Claimants must be dealt with, here we go, fairly again. That's twice now that we see it just in the snippets that I put on this slide, and in good faith, right? So this speaks again to not railroading a decision, not taking a personal vendetta against a particular claimant because an adjuster doesn't, favor the way that this injury was reported. You got to deal with people fairly and in good faith. And Rene, this last one is really important. The duty to investigate doesn't stop at the end of the claim investigation period, does it?
Right. The duty to investigate is not terminated at the 90 days.
Okay. So if, for example, we learn something later or it comes to light, maybe in a deposition, either of an employer or even in our own discussion as attorneys with an employer, that there are other aspects of this that we didn't know about beforehand. If those little snippets come to light, we've got a legal duty based on this reg to investigate those too, right?
Absolutely.
So the takeaway there is,
It does happen that you uncover information that would lend to a change in the denial and acceptance.
Yeah, and we'll talk about switching tacks on a denial a little bit as we move ahead too. Thank you.
Whoa. Okay, this looks important.
Nothing like a little subtlety, right? Yeah. The reason that there's a big exclamation point there is because we need to at least mention audit penalties. I don't want to spend a lot of time on that today. Nobody likes talking about audits or penalties, so that's a double whammy for
quick and dirty.
What's that? So we don't like it, but we need to discuss it. Here, I will say this, Rene, before we move on. This is another reg that I think people should read. Reg 10111.1. There's a lot of ones in there, I know, and the point one is important, but it's worth a read. And what people are going to discover if they haven't looked at that reg is that it's very lengthy and it's very specific in terms of acts that may lead to issues and also in terms of amounts. So, for example, a penalty for denial of liability for each claim without proper documentation supporting a factual, medical, or legal basis can be, doesn't start out this way, isn't this way in all cases, but can be up to $5,000. That's straight from the reg. So we put this slide in here just to remind folks that there is a cost to not doing what we're talking about today. And it's not just being in an awkward situation as a witness, as a claims adjuster at a workers' comp appeals board trial. There are monetary costs as well. And we have to also remember that there are additional penalties that can be assessed administratively for what we call pattern and practice of behavior that the auditors don't like, Rene, right? And that can be a lot of money, right?
Yeah, if you look at the regulation, it has a lot of math. There are a lot of dollar values in there.
Yeah. Yeah.
And like you said, you can add up very quickly if you're out of
and I think it's important for people, just as a takeaway for this slide, to understand that there's a big picture out there that needs to be remembered as we go through our very busy days. That even though you're busy, you got to dot the I's and cross the T's, because you're not the only person doing this work in your office. And you want to make sure, since we don't like audits, none of us do, that they are as painless and as positive in terms of results as we can. And, you know, a few extra minutes in terms of documenting something or making a phone call to address an issue that you have that needs clarification, that's really important, right?
I think if there's any one piece to take away from our presentation, it is the importance to document your work.
Okay. Because somebody like you in your former life as a judge may just have some questions for us later about that, right?
Yes, and it's the way for us as defense attorneys to present the information to the judges so that they can make a decision.
Right, and I should mention here, I've talked a few times about claims adjusters being witnesses at trial. We want to avoid that at all costs, and one of the ways that we can do that is to present documentary evidence to support the claim denial so that the claims adjuster doesn't have to come in and testify, right?
Right, but both sides can call the claims professional as a witness, and sometimes, you know, I don't want it to be viewed as a punitive experience or, you know, something that's weaponized by opposing counsel. Your own attorney could work with you to really present a strong case regarding the investigation that was done, the results of that investigation, and why you feel strongly that the claim is not compensable.
Yep. I don't know about you, but my knee-jerk reaction when I get a subpoena for a claims adjuster is, oh, we're quashing that.
Of course. I mean,
Yeah. Okay.
the people
So,
that we work with are extremely busy, and the last thing they need is a half a day in a courtroom.
well, and that is a presentation in itself in terms of reasons why claims administrators should not have to present witnesses at trial. But you know, we're all over that when it happens, and we have arguments that we can make. But again, documentation limits the chances of a claims adjuster being called as a physical witness at a trial, because we can prove it in other ways, essentially. So
More efficiently.
right. So that's in a nutshell the technical requirements, what we need to look at in terms of timeliness. Where are we going next?
Best practices.
Okay. And so this is the nitty gritty in terms of what I would say is the difference maybe between an average claim denial, light or kind of sketchy claim denial, and ones that are of high quality and stand up in court based on our, again, practical experiences. The law and the regs, they say whatever they say. We know what the duties are. We just went through those. But here's where the rubber meets the road. Is it going to stand up? And so the first thing that I wanted to talk about here, Rene, is timeliness. I wanted to just discuss this with you just for a second before we move on. And is the issuance of an actual denial letter within the 90-day investigation period or by the end of it actually required?
So I was surprised when we talked about this, and it's not. Right?
Okay.
But it is best practices to serve a denial letter because it serves as written evidence, right? Like of your decision and the basis for that decision.
Right. So the rule technically, as it's enunciated in the regs and in the law, is that a claim decision needs to be made within 90 days. That doesn't necessarily mean that it needs to be a formal denial letter within 90 days. We've had cases in there, you know, if you look at any of the treatises in workers' comp, you'll see a whole section of cases because people are people, and sometimes the denial letter goes out late. Sometimes it was written on a particular day and sent 3 days later. Sometimes somebody made the determination to deny a claim, documented it carefully because they're following our rules that we talked about earlier in the claims notes, but all of a sudden they got sick and they left the office, and the claims department never denied the case in writing, the claim in writing. It's not fatal, but Rene, as you say, boy, is it nice to have a claim denial letter if that's the decision that the claims people have made. And the reason is, what's a judge going to ask a defense attorney when we get to the board when the applicant's attorney says, well, first thing I want to emphasize here, Judge, is you'll see that neither side issued a claim denial letter, offered it rather, as an exhibit at trial. If you don't see a claim denial letter in a denied claim as a judge, and the applicant's attorney is saying this claim wasn't timely denied because there was no denial letter, what are you going to ask?
What are you going to use to rebut the presumption? The denial letter is the best evidence.
Right. Okay. And that may be a case where an adjuster needs to come in, or we could possibly use the claims notes. But the other question that I've been faced with, I don't know if you've had this shot at you in such a situation, but the other question that I have from a judge is, well, your claims examiner was on this file since the beginning, right? And yes, Your Honor, that's true. Why wasn't a claim denial issued within the 90 days? What prevented that from happening? And all of a sudden that puts defense attorneys on the defense even more in terms of having to justify things.
I mean, when you said that, I kind of felt myself falling back on my heels. It's a tough question, right?
Right, and we're trained in that, and it's not a big deal, and we went to school to be able to deal with situations like that, and we will. But it's not a fun thing to be presented with questions that, are not basically well supported in the evidentiary record. So the takeaway on this one is, we got to tell you, it's not necessarily required to issue a denial letter, but boy, is it a good idea, okay? Moving on to the next one, I've had questions from claims adjusters over the years that say, well, we can kind of take it easy in terms of our initial investigation because we can then use the later discovered evidence as a reason to deny the claim. So if, for example, I'm in a situation where I haven't had a chance to get to a real investigation and I need to make a claims decision and I'm just going to deny it based on a lack of substantial evidence, I can continue my investigation. You guys told me earlier today it's ongoing, so I'm going to take you at your word, and I'm going to keep investigating. I think that's a dangerous position to take. There is that exception for later discovered evidence, but Rene, in my experience, and tell me if it's different in your eyes, no judge is gonna act real favorably. The questions that I usually get in these kinds of situations from judges is, why didn't you do this earlier? Why didn't you talk to the employer? Why was it that you didn't reach out and do an employer level investigation? All of a sudden, these questions about you could have, but you didn't come up in court, right?
For sure.
And this brings up what I usually refer to as reasonable diligence. And I think that is the takeaway for this bullet point, Rene. Isn't that what a judge is going to look at?
Right, you're referencing really what we were talking about from the beginning, that has to be reasonable, it has to be diligent, it has to be fair, and it has to be documented.
Okay.
And that's what arms us as defense attorneys when we're presenting our denial as supported by investigation, reasonable and diligent search. And it's what the judges can rely on and use to form the basis of their decision.
Right, because that's at the end of the day what it's all about, evidence and what the judge wants to do. I want to say here that accuracy matters. I underlined it on this slide for a reason. Things like making sure that your denial letter has the correct date of injury. It includes carbon copies to the appropriate parties, like the applicant's attorney, the defense attorney. And I'm going to say here that I think people should consider using a proof of service when they send out a denial letter. Some clients do that we have, and some clients don't. And is it fatal if you don't? No. But can you touch on what the importance of a proof of service might be ultimately?
Well, it's really nice to have to prove that the document was served and when and by whom. It is a written record of those things. Because
it just adds a little oomph, would you say?
I mean, more than that, it is tangible.
Right. And
it's
we
not
know
someone's
that
word for it or the words of an attorney who said, well, I know it was sent. How do you know that?
Right. It's the general rule that something is presumed sent when it's put into the mail. We all know that. We've heard it from other defense attorneys too. I don't argue with that. But in certain situations, a proof of service, one of the other good things that it does is it lessens again, and again, we're talking about practical advice for claims people. If you don't want to be a witness at a trial, a proof of service may decrease the need for that by having us offer, again, written documentary evidence of what you did, not only in terms of the investigation, but also of your actual service of that claim form, or the claim denial, rather, on the injured worker and the essential parties. I had a case not too long ago that had a couple of these things as issues, and I got to say it matters. And it was something that crept into the thinking and the strategic process that I went through with the client because it was pointed out by the other side. And that is the denial letter that the adjuster sent timely had, for whatever reason, an incorrect date of injury, and it did not include service on the applicant's attorney, and they were represented at the time that the claim denial letter was issued. These are, again, I will say from a practical perspective, just uphill battles that hopefully we won't need to fight. We can fight them, we will fight them. There are things that we can do to prove that things are actually on the up and up, but we'd rather that you take the time, and the judges would certainly rather that you take the time to ensure the accuracy of these letters. So it's not just that they're going out timely, but that they're accurate as well. The next one I'll handle very quickly, Rene, is lack of substantial evidence sufficient for a claim denial. Here's where we get into that typical lawyer answer that adjusters are frustrated with from time to time. It depends. Yeah. You know, did you do a robust investigation? Have you dotted the I's? Have you crossed the T's like we're talking about? If so, then a lack of substantial medical, factual, legal evidence may be enough. And then maybe that denial letter is good just saying that. And in the vast majority of cases that don't involve specific circumstances that you may be asserting post-term psych initial aggressor like you see below, denial based on a lack of substantial factual medical legal evidence is enough if you can back it up. And then so I just wanted to emphasize that.
This next question is interesting. Is a denial letter required for additional allegations added later?
What's your take on that?
So when we talked about this, you mentioned something that I thought was really important, and that, you know, it is not required, and a later served denial letter could trigger a possible issue regarding late denial.
Yeah, it's interesting. And I had one of these come up not too long ago with a client, and you know, the argument, the question at issue with the client was they were wanting to deny some compensable consequences because they took me at my word when I said, hey, you need to document things, and you need to tell the claimant what you're doing and why. And all of a sudden, they got an email from me one day that said, I don't think it's such a good idea to send out an actual denial letter at this point in time. And that led to a phone call, and we hashed it out and got some clarity on it. But there are certain circumstances, and time doesn't allow us to go into the details on them. But I guess the takeaway here is you want to think about the ramifications of sending out a denial letter way, way after the 90-day period. There are some cases in which that's a good idea. There are some cases in which that's a really bad idea, because that may be a letter that you don't want an applicant's attorney to show up in court with as evidence. I want to move ahead.
I've been reminded by our moderator that we just have a few minutes left, so let's get to the next slide because I think it's an important one.
Right. Really quickly on phrasing, I see this all the time. Don't call a claimant a liar or non-credible. Instead, point out that there are factual inconsistencies based on an employer-level investigation. Brevity is good. I should learn that lesson myself. If possible, cite the actual case law or the reg that you're relying on. That means that you're using the wording in the law, and it means it's less discretionary on your part. Really quickly, Rene, on the determination as to whether to file for a hearing, I wanted to point out first that applicants and defendants can both do that. They can both file for a hearing on injury. Really quickly, bifurcation or separation of issues at the WCAB is appropriate in some cases. That means you're requesting a trial only on the issue of injury, right?
Correct, and that would be a priority conference.
Okay, and you'd want to do that in some cases because, number one, it saves you money on med legal if you don't have to involve a QME. If the denial is factually based, what's a QME going to add? They deal with medical issues. It's also an opportunity to bring the sides together in a formal setting to approach maybe early claim resolution in the denial stage, so you can ask for a Thomas finding and get a better deal. It also points out to the court that you're taking this one seriously and adopting a denial stance. as a whole, what I see is more resistance on the part of the judge to setting a trial just on injury. And the reason they always give me is, we don't want to try the same case twice. But Rene, we were talking about this the other day, and you raised a really good point about what else a judge is thinking about when they decide whether or not to just set a trial on injury by itself.
Right. It is challenging to write and issue a decision without medical evidence. And the medical legal evaluation provides that medical evidence. And unless it's a situation or a case where it is very clear that the only issue is fact-based and that a decision on compensability would logically precede a medical evaluation, you're probably going to be kind of continued to allow for the discovery of the med legal.
So that is sort of the default position of most judges is, hey, I need adequate evidence and I'm not feeling like we have it.
Right.
Okay, good to know. Another question people ask in this kind of a situation is, what's the difference between a priority conference and an MSC? In most of the cases, there is no functional difference. I usually file for a priority conference. There's one judge that used to be in San Francisco, your old stomping grounds, that if you filed for a priority hearing, they wouldn't set it for a trial unless there was an MSC. So they would continue the priority to an MSC, thereby signaling, okay, discovery's still open. So while we may argue that there's no difference, I have at least one experience with that judge that tells me otherwise. But functionally and legally, I don't think there's any difference. And the law tends to point out that an MSC or a priority conference is good. Really quickly, the bottom, I'll take that one. Can you file for an expedited hearing on injury AOA COE? Is this allowed? The answer is, yeah, you can, as long as some body part or condition has been previously accepted, right, Rene?
Correct.
Okay.
As long as some portion of the claim is accepted, it can be subject to expedited.
Okay, and then just a wrap up on the last slide. We hardly even need to go into it. Just a few housekeeping matters that you might want to look at before you actually head toward court. Things that you may want to be looking at and strategies that you may want to think ahead on and start your claim investigation at the very beginning of that 90-day period. Told you we were long-winded, didn't I?
Thank you, guys. That was a great session, Richard and Rene.
Thank you.
We did have a few questions, and I will go ahead and give you these questions. If your denial is based on lack of medical evidence and now you have a med legal as evidence, then I think you would owe an additional denial. Is that correct?
I'm not sure based on the phrasing of the question. I am wondering what the med legal said. So I'm going to presume that the med legal report said that the denial was appropriate, that the injury was not AOE COE. And if that's the case, having a med legal and wondering whether you should supplement a denial with an amended or additional denial letter, I think in most situations that's going to be a really good idea, because what it does is it communicates the claims decision to continue the denial stance based on new information, because again, we have a duty to keep investigating, and we've done that now. And the results of that maintain the denial. So I think usually there's no harm in doing that. There are some rare exceptions to that.
We'll get you the person's name and maybe you can give them a call and they can.
Absolutely, yeah. And I should say too, our contact information is in here. We don't care if you're a client of ours. We don't care if we're handling the case at issue. Call us, email us. We're happy to address questions, always.
Okay, we have another. So you said that the duty to investigate continues beyond the claim investigation period. Does that mean we have to accept the claim that we timely denied?
Sometimes, and I think we've all been there. We've got 100 and some odd people here, and I think most of us have been in that situation where, let's say the opposite is true. Let's say you get a med legal report in after the 90-day claim period, and you've timely denied based on the information that you had at hand, based on a solid investigation. Rene, would you agree with me at that point that with a med legal that says clearly and unequivocally that it's industrial, that would signal that you might want to think about accepting the case, right?
Yes, unless there is, issues with the medical legal evaluation, if you need a supplemental report, you can and should continue discovery. But if it's unequivocal and clear, a timely denied claim can be accepted with furthering investigation.
Right, and you made a good point. It's got to be a clear, convincing report. If it's a shaky one, we all know, doctors do their best, but sometimes, they don't address something, or it's not obvious maybe in their reporting that they've looked at all the evidence that was sent to them or any of it. And if you've got
it's not
questions,
supported by objective testing, or just
right.
Our term of art, as you know, is the substantial medical evidence.
Right, and this is a point where I would say, not to be self-serving, but to be honest and direct about what a judge is going to look at. If you have questions about whether or not what you're looking at in a med legal report is really sufficient, that might be a really good time to at least consult with an attorney. It's up to you whether you send the file to somebody like us or somebody else, but at least look at the report in detail, figure out what the arguments might be, run it by an attorney you trust.
We have one more. And you have time for one more?
Yes,
Yeah.
one more quick question. Yep.
Okay. Can I call a primary treating physician during the claim delayed period to discuss the claim and what I need to make a good decision?
Yeah,
I would encourage
and this, this last slide is still up. That's basically the third bullet point on that slide, which is there's nothing stopping you from reaching out to a primary treating physician to say, I got your report. I understand the mechanism of injury you say may be consistent with what the injured worker is telling you. Maybe is kind of equivocal, doctor. So, are you able to really pinpoint this in a supplemental report or in your next PR2 report and talk a little bit more about why you think it either is or is not industrial? Because, doctor, I've got a claim decision that needs to be made in a week and a half, and I'm hoping you can help me with that. There is nothing wrong with calling a doctor and having that conversation.
Well, thank you so much for joining us today. I know that there's a lot of great information. I've had people texting me and emailing me and saying, this is fantastic information. So remember, go to the handouts and download a copy of today's presentation. Also, if you've called in, you need to have been online to watch the presentation in order to get your certificate. And lastly, you can watch this presentation again after about an hour. You'll see it on our Macro Pro YouTube channel. So I know that those who logged in today to listen to your presentation, to see what you have to say, appreciate you as much as I do. So thank you so much, Rich and Rene. Have a wonderful, wonderful holiday.
Thank you
Happy
so much.
holidays.
We're so grateful to be included. Happy holidays.
Yeah, thanks for the opportunity.
Okay, great. Thank you.
Holidays.
Thank you.